Mr. Juhasz is a graduate of the University of Washington in electrical engineering and the University of Dayton Law School, where he went to law school while serving as an active member in the United States Air Force, reaching the rank of captain. We want to thank you for your service. In other words, he is a formidable and intellectual genius who we are extremely proud and honored to have here today. His experience includes all facets of intellectual property counseling, prosecution, and licensing, and litigation, particularly in the highly complex technology in the electrical, chemical, and medical industries. He has extensive IP contracting experience with emphasis on commercial licensing and mergers and acquisitions and R&D agreements. His specialties include patent counseling, patent analysis, patent preparation, patent prosecution, patent protection, patent licensing, patent sale, patent claim construction for when your patent is violated, patent litigation, trademarks, trade secrets, and other intellectual property needs. He is an expert on Bilski patent exhaustion. He is an adjunct professor of law at the University of New Hampshire School of Law, teaching courses on intellectual property rights and licenses. He has made arguments before the Supreme Court, which is a huge honor for anyone. He is a preferred legal services provider for IP Path to Value platform, providing 9 stages of strategic patent counseling. He splits his time between Bellevue and Houston, and we are very honored to have him come and speak with you on how to protect your IP as you continue to develop over your lifetime, and especially as you enter higher education with higher education's rapacious tech transfer policies that seek to capture all IP that passes through their territories. I cannot encourage you and those with you enough to listen and pay attention. Again, I want to thank Mr. Juhasz for his service in the United States Air Force and being here today. He will give a talk. Afterwards, he will take questions. Mr. Juhasz, the floor is yours. And again, thank you.
My father passed away a number of years ago, and he spent a good part of his life giving back to the community through Boy Scouts, through the Elks Club, through Hungarian Society. He even did a couple of science fairs, and I respected that. I really respect people that give back to the society. I have great respect for Dr. Stein, Dr. Huey, Dr. Bauer, and all of the judges here today, and all the people that volunteered their time to make today's event a success, because they've really given back to society. They've made the world a better place. You have all done amazing work as students. I had the privilege of walking through the fair area and seeing the exhibits. That's very impressive work. I expect that all of you will rise as future leaders in the United States and in the world. And I just hope that as you take your role in society, you never forget to give back to society. Now, with those few introductory remarks, let me turn to the topic of today's presentation. So today's topic is going to address 4 themes, and one is what high schoolers should know about intellectual property, and what they should know about who is the inventor or creator of that intellectual property, who is the owner of that intellectual property, and what you can do to improve your chances of continuing ownership or at least controlling the destiny of that IP. In today's climate, with all of the federal cuts in funding, what jumps out at me is the cuts to the research organization, research institutions, and that's a big hit for the research institutions. You can bet, or I can bet, dollars to donuts, that they're going to look for other ways to generate funds to support the research. And I think the area of IP and the IP coming out of the student body is fertile grounds for that. So I expect institutions will be becoming more and more aggressive in trying to get ownership of student IP. And so it's important for the students to know how steps to take to hopefully keep that from happening. So I have 4 case studies that I wanted to share with you, because I think certainly in the law it's all about facts, and once you understand the facts and patterns, and you can develop patterns, you can kind of get some guidance as to what's likely to happen. So there's 4 what I view to be classic examples of students that were at institutions and found themselves with problems on ownership of their IP with the institution. And the first one is this is the first case study, and I'm going to ask, has anybody heard of Mark Anderson? Maybe a raise of hands. Okay, some people have heard of it. Heard of him? Eric Bina? Anybody hear of him? Probably not. What about Netscape? Anybody here? Okay. Good. And then what's interesting is that Anderson had a really difficult time with the University of Illinois once he developed a platform that ultimately became Mosaic. We're going to talk more about that, but I'm just going to touch on these 4 case points to point out who the actors were, their status at the university, and the institution that they ran into problems with. The second case study is, has anybody heard of Larry Page? Okay, more recent, it's more current. What about Sergey Brin? Okay, and Google? Who hasn't heard of Google, right? Did you know that Google, in its early foundations, had some issues with Stanford University over ownership of the platform technology that's Google today? And I'm going to talk more about exactly what that is, so you get some idea of where the problems were. The third case study is anybody here Mark Zuckerberg? Everybody probably, right? These are current people. Google is like late 90s. Zuckerberg is probably the same time period. Anybody know Facebook? Probably everybody, right? Show of hands, yeah. Okay. And Zuckerberg did most of his work at Harvard University. And interesting there was no claim by Harvard University to the innovation of Zuckerberg, but there was by some other students that he collaborated with. The fourth case study is, anybody here of Pete Dvorsky? Probably not, I haven't heard of him either. And Progress Technology Corporation? Probably not. So he, too, was a student at the University of Florida, and he ran into big problems with ownership questions of his innovation. So let's talk a little bit more. We're going to dive down a little bit more about Netscape. Oops. Okay. So while an undergraduate student, and he was a part-time assistant at the University of Illinois, he had access to basically University of Illinois' like supercomputer. It was something that only institutions and military had access to. It was Unix. It required, the interface was required heavy computing power to configure, and he had access to that as an undergraduate student, and he was paid as an undergraduate student to give that access. He did work for the university on that, but in the course of that work, it sort of like struck him that, because the thing about Unix is it was only available to institutions and military because it required heavy computer functionality in order to run the interface. So it occurred to Anderson, maybe we can create an interface that's can operate off of personal computers and then make it available to everybody. And that's what he ended up doing. He created, ultimately became Netscape, but I don't want to get ahead of the story. He created a company, it was called Mosaic. He left the university, and with his partner, he created a company called Mosaic. And basically they put together coding for a browser. It's one of the early browsers, pioneer browsers, and it became hugely successful because first of all, it ran off of personal computers, and second, it used HTTP language, which was an easy language, required fewer configuration settings, and so on. And it allowed for hypertexting. So, previously in Unix, you'd have to type in the address of the landing page you wanted to go to, but now with Netscape, you could use these hyperlinks and kind of have it do it all for you. It's just really user-friendly. And it also allowed for presentation of pictures actually on the screen. Over here you can kind of see what the sample landing page for the Netscape browser looked like. And needless to say, once the business got off the ground, the University of Illinois got wind of it, and they were not happy, and made a claim to ownership. And it was quite a struggle. And ultimately, Anderson ended up settling and paying $3 million, which today seems like small money. Now that you've got Apples and Googles running around with $1 trillion of valuation, but back then $3 million was a big amount of money. Fortunately, the settlement happened before Netscape took off, and Netscape, Anderson was able to retain the ownership of the software, but each had to change the naming, the whole branding to Netscape. And Netscape ultimately was brought up by AOL, and it's filled the back of the line after other browsers like Internet Explorer came out. Next case study is Google. So Larry Page was a grad student at Stanford University, and he came up with, for his work at the university, for his graduate level work, he came up with a great idea, which is Google today. And basically, the idea was to, before Google, there was the internet that allowed you to reach all these different landing pages, across the universe, but it was not structured. There was no hierarchy of which landing page you would end up on. You could do the same search at different times and come up with different results. It all kind of depended on, how you landed in the internet universe and so on. And so Larry Page had this, actually it's a brilliant idea, and he thought, what, we should somehow rank the landing pages on the internet. And his brilliant idea was, let's rank them by the quality of the sites that link to them, with the premise that if a landing page has sites linking to them that have greater value, then that means that particular landing page, has a greater role and is of greater significance and more important in searching. And he did but in order to prove out his concept, he had to use supercomputers, and Stanford had a supercomputer. It was funded by the National Science Foundation and NASA. And so Larry Page made an arrangement with Stanford University to get access to these supercomputers. And he used the supercomputers. He proved out his theory because, effectively all these websites got ranked based on the quality of the links from other websites, and it came up with a listing. So when somebody typed in a search anywhere, the listing would be the same, and everybody would come up with the same listing of websites. When it came time to patenting, though, it was not Larry Page, but the Stanford University that walked away with ownership. And there on the far right, you can see the cover page of the patent. You can see Larry Page, upper left corner, next to the number 75 in Paran is the inventor, Larry Page. You can see there's a closed parenthesis number 73. It's titled Assini. It's in the upper left corner again. You can see the Assini, which is the owner, is Stanford University. So here we had a situation where you had an innovator student who came up with a brilliant idea, and yet Stanford ended up with ownership. Now, there is, and I was talking with Dr. Bauer about this before the talk, to me one of the greatest legislations in the United States in terms of advancing technology is the Bayh-Dole Act. And it basically said that the government will fund research, and that funding, as a result of the funding, any innovation that comes out of it will be owned by the university, so long as they commercialize it. If they don't commercialize it, then the government will have marching rights and take it back, and then the government would make it available to other people to use. But it's really a win-win because the institution gets ownership. They not only get to develop this technology, which without the government funds, they would not be able to develop, but they were also able to own it and then commercialize it. In the case of Stanford, they ended up exclusively licensing the patent to Google, and in 2015 they had an equity interest in Google. They sold their equity interest for like $315 million. Compare that to Netscape's $3 million settlement 25 years earlier. It just goes to show how more valuable these types of technologies are becoming. But that's what happened in the case of Google. In the case of Facebook, what happened is Zuckerberg was at Harvard University. There were some Harvard students who had an idea. There were three of them that had formed a company, if you will, a partnership, if you will. And it was basically about social networking. And they had a programmer that started the coding but didn't finish it. And so Mark Zuckerberg got known as a good programmer. So this group of students brought Mark Zuckerberg in. Two of the students were Winterboss. In any event, Mark Zuckerberg he looks at the coding that was being done by this, that he was brought in to look at, and he thought, I can do this better. He looked at the architecture for that, the coding that was done by the prior programmer, and he's studying at Harvard, he's learning all these things, and he's a smart guy. He says, there's a better way to do this. So he ended up doing his own solution and started Facebook, and became hugely popular. Interestingly, Harvard did not lay a claim to ownership. And this is notwithstanding the fact that Zuckerberg did most of his programming in his dorm room, and he used the Harvard University internet. He used power electricity at Harvard. He set up a server, cloud server. That was all. Everything was done through the Harvard internet, and yet Harvard did not claim to ownership. And we're going to talk. Again, I'm just trying to lay out these four case studies so you kind of get an idea of facts that play into who's going to own this stuff at the end, who's going to own innovation at the end. And then we're going to wrap it up. I'm going to show you how and what factors you should consider when you start your life at the university, what you should consider doing in your practice in order to give you the best shot at walking away with your IP. The last example is this Dvorsky, and he was an undergrad student, University of Florida, and he was hired, and as an undergrad, he was hired to do work on a research program that was actually funded by this company, Progress Technologies Corporation, and effectively PTC had agreements in there. Everything was supposed to stay confidential, and everything was supposed to be owned by PTC. Well, Dvorsky came up with a great idea in the course of this work, and he thought that it was his idea, it's his invention. So he basically packed up his bag, left the University of Florida, took his lab books, started up a business, and then actually filed for the patent. Pretty aggressive stuff. Needless to say, the PTC was not happy. They didn't have the agreement with Dvorsky, so it was the University of Florida that they put pressure on to sue. Dvorsky ended up getting 1 year of house arrest and 15 years probation. Yet it didn't fare well for Dvorsky. And again, there's certain facts. You can kind of glean the fact that he was hired on a research project that, with agreements in place that governed, that talked about innovation. You can imagine how that one worked out. And I'm going to roll all this up. But after we talk about some things, but let me just, for that roll-up, let me just give you a preview of how the facts lay out. So you got in decisive facts on the IP ownership question. In the case of Netscape, there was extensive part-time assistance of Anderson and use of the university's supercomputing facility, which no one had access to except the few that were selected. So it's sort of like the proposition is Anderson would not have done what he did but for the university resources. In Google, it's very similar. It was gradual level, Larry Page had gradual level access to the supercomputers that were funded by the National Science Foundation. So once again, in Larry Page's case, even though he had the idea, he couldn't prove it out. He couldn't prove it out with supercomputers. And it wasn't until they got the use of supercomputers he was able to prove it out. So, in theory, it's like he would not have been able to do it but for the resources of the university. In Facebook, the university, only thing the university provided was dorm, power, electricity, and internet. It doesn't really go to the laying claim to any ownership. And because all of it was what Zuckerberg did was within the sources that was offered to every student, Harvard did not lay claim to the Facebook innovation. In the case of Dvorsky, he's actually hired, he's signing an agreement where the PTC is to own it, and he violated that agreement. So, 3 W's on how to help you control your IP is you need to have an understanding of what is IP. You need to have an understanding of who is the inventor, creator, and then you have to have an understanding of who's going to walk away with ownership. So you need, if IP is standing before you, you need to be able to see it. If you don't see it, you're going to miss it. You need to know what it is. And then you need to know when the IP comes into existence, who's the creator, and then of course steps to take to keep that IP from getting into the hands of the institution. So let's talk about IP. There's different types of IP, and I think Dr. Bauer alluded to some types of IP in his introduction. But effectively, there's real property, there's personal property is intellectual property. Real property is fixed. It's like it doesn't move. It's like ground. It's like land. It's like a house. You don't move the house. It's like things that are permanently attached to the house. Those are all real property. Personal property is things that are tangible. You look and feel, it exists in real life, but it moves and it stays on the person. It's called personal because it's typically associated with the person. It's things like personal computer. It's like your automobile. It's like your iPhone, papers and effects. And then you have intellectual property, which is something that's intangible. It's like you can't feel it, you can't touch it, but it's there, it exists. It comes from the mind. There's 5 buckets or categories of intellectual property. Patents are one of them. There's copyrights, there's trademarks, there's trade secrets, and then there's a catch-all bucket that includes things like unfair competition. Some IP practitioners put misuse and trust in that bucket too. Sometimes privacy can be in that bucket too, and data can fall in that bucket too. So let's look first at a patent. So a patent is an invention which by statute is defined as it's one of 4 things. It can be subject matter of a patent can be as an invention, which can be an inventive process. It can be an inventive machine. It can be an inventive article of manufacture. It can be an inventive composition of matter. The thing with patents are Utility patents effectively patent functionality. It's basically you have structural elements of a design, whether it's a process, it could be steps of a process, it could be functional elements, structural elements, or elements of a machine, article, manufacturer. It can be the chemical composition, particular composition of a matter. But it's not only that, but it's also how, in the case of like the elements, how they, not only the identification of the elements, but how those elements work together to do whatever it is the invention does. That's what a utility patent is. There are other forms of patents. There's a design patent as well, which protects the form factor of a product. I'm going to show you some examples in a minute, but it's ornamental. It protects the ornamental feature of a product, as opposed to a utility patent, which protects the functioning of a product. And then you also have a third category, is plant patents. I didn't see any plant technologies in any of the science fair presentations, but you should know that there's a patenting available. We'll talk about that in a minute. So let's talk about utility patents. So I've got here some examples just to show you. I'm not going to spend a lot of time on it, but I think it's important for you to kind of know what types of things that you can patent, just so you start to get familiar. So you see, when you see something, an innovation before you, you see this is maybe something that I should think about patenting. I think a classic patent is the patent of the Wright brothers. Again, before this talk, I was talking with Dr. Bauer about, we were talking about different areas, different points in time in the history of innovation, and certainly the coming of age of the flight age in the early 1900s was very exciting. I mean, there was like international contests. There was a Paris International Fair to give an award to the person that could actually come up with a structure that could stay in the air for a predetermined period of time, whatever that was determined to be, to demonstrate flight. And it was the Wright brothers that ultimately won. And the interesting thing about their patent is what they came up with. Their invention was it's called the aileron. Today's technology, the ailerons. It's basically the flaps. See, you see number one is the wing, the upper wing, and you see there's like this phantom line, broken line, that shows the wings and flap up and down. And that's what gave stability to the airplane. It allowed the airplanes not only to go up and down in a vertical, move in vertical, but also to roll. And that's ultimately what was the start of was aviation, was this innovation of the Wright brothers, which the Wright brothers patented. But interestingly, they didn't get a lot of commercial return on it, because as inventors, they're not necessarily the best at marketing. And in fact, it wasn't. I don't want to get into it because it's for another topic, for another discussion. But not all inventors are good marketers, and effectively there was a company called Curtis that came up with a better marketing strategy and walked away with the market. But it was certainly Wright brothers that created the technology and innovation to make it all happen. So that's an example of a mechanical one. An example of a simple electrical one would be, it's called porch piracy. It's a big problem today where Amazon drops packages at a house, and no sooner does the driver drive away than some thief lurking in the bushes runs up, grabs the bag, and runs away. This is basically like a smart eye, where the eye it's programmed. When the driver puts the box down, it's programmed to basically set a trigger, which is going to trigger an alarm unless you set in the code that deactivates the alarm. A very simple idea, but that's what that second one, just to give you an idea. Sort of like, you can see on the far right, the communications through the cloud, through the internet, or through regular wireless communication, through the phone communication, GSM, PDMA, whatever, to cloud servers, to police stations, and so forth. So if somebody trips the alarm, not only does the alarm sound out nearby, so neighbors can step in and act, but also the police from far away are notified and can come and investigate the situation. I put had I seen the exhibits beforehand, I probably would have put in some other slides here because I think today's fair showed a lot of behavior, a lot of gene stuff, a lot of biotech stuff. I saw quite a bit about airplanes, artificial intelligence. We'll talk about that. I do have a little bit to say on that. But I did put in this example on cancer detection. It's basically, you basically have a sample and you apply an assay to it that to determine the expression of the gene, and you run the test on samples to determine a standard, a baseline, and you know how the different genes are going to express themselves once this immunoassay is applied to it, and then you use that as a test for future testing. And so you can see a gene expressing at a different level than the standard, and that could be an indicator, a marker that the person has maybe prone to cancer. That's a cancer detection pattern. And the last one is more of a this is more facts, gene cancer. The last one is more biotech, like implants. In this particular case, it's an interactive skin. It's basically multi-layered skin with capacitors, electronics, and a covering with implantable material, biofriendly implantable material. You basically put it under the skin, and you can see in like figure 4A, it's there. It does things. It's like a computer on the body type of a thing. So that would be an example of last example again. Let me turn to the design patents. We talked about design patents as protecting the form of a product. One of the earliest copyrights that was hugely successful is one on the right. It's the copyright Bartoli. It's the design patent, rather. It's a design patent on the Statue of Liberty. But today, probably the more known design is the iPhone. And this design patent, interestingly, there were a number of years ago, there was this big battles between Apple and Samsung, and it involved a number of design patents, but also a whole lot of utility patents. And the interesting thing is that most damages, Apple got the most damages out of the design patents and not the utility patents. It was kind of interesting. In the bigger scheme of things, the real value of Apple of the lawsuit was not the damages from design or utility patent infringement, but rather it was having the ability to file a lawsuit to create disruption, to cause Samsung to second guess everything it's doing and look behind its back, and that resulted in I think 2 or 3 points of market share, which translates to multi-billions. So that's where Apple got its value out of its design patents. The last example is a planned patent. This is more just to be aware. I don't know that it's happening to anybody here, but basically you can patent asexually produced plants. That's something that is patentable as well. Artificial intelligence, if it's used in an innovation, that the product can be subject to a patent, but it's provided that a human is involved in that creation and provided that the human makes a significant contribution to the product. So I did notice there are a number of artificial intelligence exhibits out there, so those of you in that field should be aware that there is patenting available there, provided that you are a contributor and a significant contributor. So let me talk a little bit about copyrights. Copyrights is an artistic expression that expresses an idea. It expresses an idea a certain way. It's put into tangible media. And by tangible media, it means it doesn't evaporate. It stays in time. The typical would be things you can touch and feel, but software, the tangibility of the software is the magnetic medium in which it's fixed. Examples of copyrights can be books like Harry Potter. We got video, audio video like Game of Thrones. Music. There's the Beatles album. There's drawings like Steve O. William, right? We've got 2 pictures of prints. One is a photo, which is copyrightable, and also a drawing that was done and was actually litigated by the Supreme Court. You have the statue of this little girl at Wall Street. That's an example of a sculpture. In the lower right is Office is one example. Software is patentable. So for those of you that are heavily involved in coding, that you should think about patenting. You should think about patents with coding as well, because software is patentable. So the last is copyrightable. The thing about copyrights is, and we're going to talk a little bit more about this a little bit later, but it's what you create on your own is your own and you can use. But if you include something that was created by somebody else, then you have a problem. And there's guidelines provided, and I won't belabor that in this short time I have to talk here. But I emphasize purpose and character. So these are the four bullets. Purpose and character of your copyright, the nature of the copyright, the amount and substantially of the amount that was copied, and the effect of the use on the commerciability of the prior work. It's really the purpose and character. And I think a great example there is Google Snippets. They took the whole library of books and they basically took small sections. And when people searched for the books, they came up with the small sections, and you could look at like maybe a couple pages here, and then you miss a bunch of pages. And that was litigated, and the courts ultimately determined that was transformative. So it didn't take away from the commercial ability of the author's books. In fact, it even made the author's books more readily available, as more people knew about it. A trademark is a mark that's put on a product or a service, such that when people see the product or service, they buy the product, they know the quality of the product or service, and they see the mark on it, they associate the maker or deliverer of the product or service based on that mark. And if the product is a good one, then they'll recognize that it's coming from a good source, and they'll have confidence in buying it. A good example is a can of Coke. When you buy, you know what it tastes like. You buy a can of Coke, you know it's coming from Coca-Cola company. You know what you're getting. But if you buy a Coke that's got this generic label on it, it's like, what's it going to taste like? You don't know who is delivering it. There's question marks. That's the power of the trademarks. Some examples of some trademarks. Coca-Cola. 10 years ago, Coca-Cola was the big one to talk about. Today it's Apple and Google as far as trademarks, because these are marks on products. On services, you've got Starbucks and American Airlines as examples of that. There's this sort of periphery of trademarks. It's known as trade dress, which is sort of the skin of a product, typically packaging. The bottle of Coca-Cola or the packaging on Jif, or even the Apple phone are good examples of that. And then we turn to trade secrets. Nearing the end of this. Trade secret is information that's owned by somebody. It's been kept confidential, and it gives them a competitive advantage by being secret. And unfair competition, and there's data. Those are other forms of intellectual property. we'll skip over that due to the shortness of time here. So that should give you an idea of what IP is. Let's talk now about who's the inventor or creator. So in the case of a patent, there's basically two steps to an invention. One is conception, and one is reduction to practice. And at the end of the day, it's the conception that matters. Whoever contributes to the conception is going to be an inventor. So someone comes up with an idea, and they say, okay, to the research lab, their assistants, go ahead and put this together. And the research lab, they put the device together, they do the methods of this chemical process. What the assistants are doing is not invention. Reduction practice is not invention. It's basically coming up with the idea. Now, it could be that the assistant, in the course of doing this work, comes up with, runs into a problem, or comes up with another idea for doing it. That would be a new invention, but it's not the original concept. So I've highlighted in yellow, conception is the key to determine who is an inventor of a patent. In the case of copyright, it's, again, a two-step process. It's coming up with the concept and then fixing it in tangible media. And once again, I highlighted in yellow that creation is the key here. It's whoever comes up with the idea and whoever contributes. So sometimes it's a collaborative process. Like in the case of the Beatles, you'll see many of their songs are they're co-authored by Lennon and McCarthy. In trademarks, once again, it's a two-step process. It's creation of the mark and actually using the mark on a good or service. Once again, I highlighted in yellow that creation is the key. It's the creation of the mark. Whoever contributes, it can be a single person, or it can be in a room where full of a number of people and there's brainstorming, you come up with an idea. Those are the creators of the mark. And lastly, with trade secrets, it's the creation of something confidential. It gives you competitive advantage. You keep it confidential. And once again, it's the creation that defines who is going to be the innovator of this trade secret. Not who implements it or who protects it, but it's the one who came up with the trade secret. Now, let's talk about. We now know, when we talk about patent, or you talk about IPs, you know a little bit about what IP is. We talked about who's the inventor. Now let's talk about who's the owner. So, it's based on the relationship of the inventor or author to a third party, if there is such a relationship. If the inventor or creator does it by himself independently, there's not a problem. When you've got other people involved, you have these relationships. And depending on the relationship, the inventor creator is going to own it, or the third party is going to own it. And sort of when I started law school, that was probably one of the first things I learned about law, is that law is all about legal relationships and defining the laws governing the legal relationships. And it's definitely very true here. So there are three basic relationships. I mean, there's a lot of varieties. But the first is an independent consultant. Another is work for hire. Another is employee. On the next slide, I have I kind of show the kinds of factors that determine what kind of relationship an inventor or creator is going to find himself in. On the far left, you've got a complete independent, and we will try to make this presentation available soon after I get the conflicts, so you can study this. There's a lot of bullets that we're going to go through, but effectively you work on your own. You've got your own tools, you've got your own skill set. You pay yourself. You hire yourself. You pay your own taxes. That's what an independent does. And we're going to relate all this stuff to those four examples we talked about at the start. We have an independent consultant. So it's somebody who, actually, let me talk about the other extreme, is the employer. The employee. So an employee is someone who works for a boss. And in this case, it's basically the boss has the tool set, provides the tool set. The boss typically provides the training. The boss That's where an employee is. In between, you've got these two categories. This is where you as students at institutions are going to be, finding yourself trying to figure out where you fall. And the idea would be to keep yourself as an independent consultant, because then independent consultants own their own work. But if you end up getting trapped as a work for hire, then the innovation goes to the whoever hired, whoever commissioned the work. So let's look first at independent consultant. Has his own tool bag, does his own work, his own skill. Work for hire is one where it's typically an independent consultant who's hired to do a particular project. So typically you have a case where an artist will be hired to do a sculpture. Like earlier we showed a picture of copyrights. There was a sculpture of a little girl at Wall Street. And I think that was litigated. I think that was one of the ones that was litigated. But there's an artist that's hired to do the sculpture. There's an entity that wants to do the sculpture, and then they hire an independent consultant with an artist, and in fact a sculptor in that case, with the expertise to do the sculpture. And so the artist sculptor does the work, and the work is done. The question becomes, who owns it? Well, under work for hire, the one who commissioned the work actually has an agreement that we're going to own the work. And so it's typically independent consultants who get tagged with this or deal with this problem. But it can happen in an employment situation as well, where employment is usually you have a defined work. But if you're taken out of your work to do a special project that's not what you were hired for, you effectively become an independent consultant inside the umbrella of the company. And you could find yourself facing work for hire problems. And again, there's a lot of bullets on here, but we're going to work to get clearance from the obligations that that need to be cleared for this to be able to release this, so you can study and understand this better. So the next slide. It's sort of in terms of ownership, the independent on the left owns it. The independent consultant is going to own it unless he's got this work for hire agreement where the ownership goes to the employer. Then work for hire is the independent gets snagged into that category, or an employee who's working outside the scope of hire. They're going to get snagged in the work for hire, in which case the invention is going to be owned by the whoever commissioned the work. And then the employee, where it's typically owned by the employer. So I told you we were going to come back to look at the 4 examples and how these, now that you know a little bit more about who the inventor is and how the ownership plays out. In the case of Netscape, if you look at the key factors, and I've highlighted it, part-time assistant, he got access to the Unix, which, not back then, it was really something to get access to. Not everybody had it. And he had, and Anderson had the ability to really study this and do a lot of thought. There's a lot of resources that of the university that flowed into Anderson's innovation. And that's why Anderson ended up settling with that. That was a case, I'm saying it's likely an employee or the employer will own it. Although Netscape ended up walking away with the ownership after paying a settlement. In the next case, Google, here you have, a grad student who's got these algorithm that needs to be proven out using these supercomputers. Once again, Larry Page would have been able to prove out his concept without access to these supercomputers, without his resources at the university. That is not something that's made available to everybody. And so in this case, it's highlighted as a likely work for hire, and there's some reasons why. Effectively, he used resources that were very selective as to who could use it, and the quid pro quo was ownership of the innovation in Stanford University. In case of Stanford, or in case of Facebook, Here, Zuckerberg developed the Facebook app in his dorm room. He used the internet, the Harvard internet, but he didn't use anything more than what Harvard allowed internet students to use. And every student was using internet, not coming up with innovations. So Harvard had a very weak case for ownership, and ultimately they didn't pursue. I mentioned in the fact pattern earlier that there was these partners that he was hired to do work for that he ended up learning from them and then leaving them. They ended up suing him, and that case went up to the Supreme Court and back again. Now one did settle for quite a few dollars, hundreds of millions, I believe. The last case in Dvorsky, here he was working on a research project, and if you look at yellow highlighted, it was under confidentiality agreement. Here there were agreements that effectively brought him close to looking like an employer. And so the University of Florida actually flowed to PTC. So key takeaways on how to keep your IP from institutions is first and foremost, you should study your institutional policies on your IP, what it covers, when the IP has ownership, and when it does not. You should look to make sure that work that you're doing on campus is not going to be grabbed by the university. You can't do in terms of ownership on innovation in your student institution contract. So when you sign acceptance papers, go to university, you need make sure you read the fine print, make sure you're not signing something that says everything you do in the next 4 years is going to be owned by the institution. You should be careful about any contracts, that's the third bullet, representation commitments you make. See, in the case of Facebook is a great example because even though Zuckerberg went out and did his own thing, there was certainly a lot of representations made to the partnership that brought him in to work on their stuff, which he never finished. And he got tagged for that, and it cost like a couple of $100 million. The fourth bullet is the more significant the contribution is, that the institution's contribution is, the more likely they're going to lay claim to it. So if you're at a graduate level, you got to be more concerned because you're doing more advanced work, you're getting access to more. The university is opening more doors for you and making more of their resources available to you, and that's when universities are going to try to claim your IP. The fifth bullet is steer your IP away from all of the above as much as possible. The last bullet, which is a very important one, is whatever you do, you should document your work. By that I mean, write it up, and it's important to date it as well. A lot of times, in the case of innovation, we having a witness corroborate, your invention is extremely important and helpful if there's ever a litigation. Some other takeaways. Are you building on a research of an institution or a taught course? If it's more based, if you're in a research program, chances are more of the stuff you're going to do there is going to, the university is going to have more of a claim to it. If it's just a course that you're taking, you get an idea from the course. There's a lot of arguments why the student should retain the ownership of that. Last bullet, are you building on project work, mandatory coursework, or extracurricular? If it's project work, it's most likely the institution. If it's the latter, it's most likely the student. Now, Bill, Dr. Bauer, how much time do we have?
You have as much time as you like, sir.
I could go 10 more minutes and open for some questions.
Okay.
Is that okay?
Yep. Does he have the microphone?
Right.
The moment microphone?
Yeah. This is a roadmap for protecting your IP, and again, it's got a lot of bullets. I really don't have time in the short time I have today to walk through everything. But once you see this, we'll work hard to make this available to everybody. You can see a number of things that are important for protecting your IP. It's a number of the things we've talked about already. Knowing your institution's policy, knowing what you sign. Be careful with contracting with third parties or representative third parties. documentation we've got in red here throughout. That's really, really key. And by documentation, I mean writing it up is really critical, dating it, and as I mentioned, having somebody witness it. Now, I should say that when you have somebody witness it, that person should be under confidentiality, because all of your IP has tremendous value while it's confidential. For instance, a patent, you have time to file for a patent, and once you file, it's not made public for 18 months. That's a huge window of confidential time that you can develop your business, commercialize your business, get a huge competitive advantage. So make sure you have your witness under a confidential agreement if you're going to have a witness sign. You know, the same really goes for copyrights, trademarks. I mean, trade secrets is mandatory. I mean, the signatures, the documentation, trade secrets is more documenting the policies. It may not, witnessing there is may not be so important, but it can be, you know, litigation. If you have to prove what your process is, it's nice to have somebody corroborate, you know, the documentation of a single person. So beyond Netscape, we got various scenarios. I'm going to rifle through these real quick. And again, this is a lot to take in one talk, but I'll rifle them through because I think these are the pointers that are going to help you as you move forward. Scenario one, you develop an idea in your dorm room. You use no university materials, no university assignments. It's your own and university debt, no university resource, no university policy, sign no contracts. I mean, here it's clearly yours. You know, next scenario, here you're using everything is the same as before except for using the university internet. You know, this is the Facebook type of example. So this would be where you would own it. You should be owning it. You know, the next one is same as before, except here you're using university coursework and university assignments. I mean, if it's standard coursework and assignments that's made available to everyone, you should use it. It should be yours. It's not unless you get into a Larry Page Google situation where you're starting to deal with you know, high levels, you know, university resources and materials that it's a problem. So this one is innovation, should be yours. You know, next one is you know, it's basically using university, everything, you know, using more than university. This is, you know, these are Facebook examples. I don't really know how much of what Zuckerberg learned at the Harvard he used in this stuff. So it could be, you could apply to any of these. The next scenario, in this one you have the fifth bullet, the yellow highlighted, supercomputers, special equipment. I mean, here, this is the Netscape Google example, and ownership is likely going to be, you know, in the university, although Netscape ended up with a settlement. You know, scenario 6, you know, here you've got yellow highlighted first bullet, special project. You know, this here you're walking in the door of special resource the university is giving you. You know, those are the indicia where you're likely to be the ownership is likely to be with the university. And then you've got the last example is Dvorsky. Say yes, the Dvorsky example. You know, where you actually sign an agreement, you work on a university research where ownership is in, you know, the university or third party. Here it's clearly university owned. So the final thoughts for today's talk is, you know your institutional policy, document your IP, develop a strategy to protect your IP, take the steps to protect it. These include like patenting, copyright registrations, filing for trademark registration, obviously filing for patents, putting policies in place for trade secret protection, and then policing and enforcing your mark. And if you actually use to-dos, you should be in a real good position to hopefully own your IP, if not ensure it's guiding it and controlling it going forward. As closing remarks, I just want to say I hope my talk has enlightened you a little bit on sort of what IP is, who the inventor or creator is, who the owner is, and some things you can do to protect yourself. I want to thank Dr. Stein, Huey, and Bauer once again for inviting me here today. And I want to thank you all for being a really good audience. I wish you every success on your future endeavors and future leaders of America. United States and the world, and I hope you don't forget to give some of your time giving back to the community. And that concludes my presentation. Yeah, sure.